A very good evening to my dear MOS members and the ophthalmic fraternity and the other medical fraternity, whoever has joined today. A warm welcome to all of you. It's late 9:30 now. The right time we are starting this. We have with us star faculty for today's topic. In line with the MOS, as they had formed 21 committees, out of which the Medical Legal Committee is one of the most important committees. It has been chaired by Dr. Anand Deshpande, sir. He is very much there as a speaker and a faculty and a panelist. We also have with us a young and a dynamic gynecologist with us, Dr. Manish Machwe, who is going to speak, who is the chairman of the Ethics and the Medical Legal Committee of FOXI, that is a gynecologist. So he's chairing that too. We have with us Advocate Mrunali Kamlapurkar ma'am. She is also more into medical negligence. More about her by our moderator. Welcome, ma'am, you too, to our this webinar. We also have Dr. Sanjay Patil, my close friend, an ophthalmologist for excellence. He is the chairman, National Board of India. He is also past president of the Indian Medical Association. A warm welcome to all of you. Today's two topics, which the two speakers we are going to talk about. The first one is how to avoid achieve litigation-free practice. That is by Dr. Manish Machwe. And of course, the new Consumer Act has come. So the biting teeth about it will be spoken by our chairman, Dr. Anand Deshpande. Over to you, Dr. Sanjay Patil, for further moderation of the whole session.
Thank you, MOS President Dr. Taswala. Good evening, everyone. At the outset, I would like to thank the organizers for giving me this opportunity to moderate this session, very important session on medical legal aspects. Friends, let us congratulate MOS that this is their 69th event.
Yes.
And also let us congratulate that they have considered this is very important topic, that is a medical legal webinar. So we congratulate MOS organizers for this. Friends, today the doctors are subjected to the trials of Criminal Act, Civil Act, CPA, and the Medical Code of Ethics and various acts. And these acts are really they are damaging, or they are producing the damage to the profession. The reason behind this is, the main crux is these acts are misinterpreted at many times by the non-medicos, and they are not expert in the medical field. And friends, the ignorance of law is not an excuse. So today we have a panel of medical experts. There are two doctors. One is from our fraternity, that is ophthalmology. Second is from gynecology. All three panelists are lawyers. Two are doctors. One is from our ophthalmology. One is from gynecology. They are helping our members day in and out to rescue them from their medical legal issues. And as rightly said by Dr. A. Deshpande, that they are fighting for doctors. Manish, I have seen him in Pune city. He is always for our members. So today I request everyone to participate actively and put your questions to these panelists. And we'll listen one by one. First, Dr. Manish Machwe, and secondly, Dr. Deshpande. Coming to the first topic, that is achieving litigation-free practice of ophthalmology. He has modified the title, and our faculty is Dr. Manish Machwe. He is MD, DNB, MNA, MS. He has done LLB. He has done diploma in endoscopy from Germany, and he is a consultant gynecologist from Pune city. He is a MC member of Indian Association of Gynec Endoscopists, and he's mainly a chairperson of Ethics and Medical Legal Committee of FOXI. So I request Dr. Manish to start his presentation. Thank you. Manish, unmute yourself. Manish, unmute yourself.
Okay, now am I heard, sir?
Yeah. Very much. Very clear.
So the new normal is my slide seen, and the second new normal is as my voice heard. So if
Yeah,
those
both
two
of
are
them.
yes, if those two are yes, then I'll start.
Yes. Please go
So
ahead.
Absolutely.
at the outset, let me put my gratitude and thanks to Dr. Taswala sir, Dr. Patil sir, and Dr. Joshi, Dr. Deshpande, such a senior person, and everybody who thought that this was a good idea to discuss medical legal issues pertaining to ophthalmology and put forth some facts. Although I can understand that if we have to really discuss everything pertaining to litigation-free practice, it would be a 3-day conference. So, and to sum it up in 20 or 25 minutes, a little difficult, but I'll try to put some cases which will, help you and, decide how your practice should be or what changes you need to do in your practice. So litigation-free ophthalmological practice, is it possible? This is always my initial slide. I pray to Lord Ganesha to sail me through this. I always thank all my teachers, not only at BJ Medical College, but also at ILS Law College, for it is only because of their blood, sweat, and tears I do what I do today. Thank you for your introduction. Again, there are different aspects. So when we consider how to achieve litigation-free practice, there are medical issues, there are legal issues, there are issues pertaining to training, indications, surgical procedural issues, guidelines, protocols, safety checks, documentations, consents. Then there are allegations which are very common. There's something called as res ipsa loquitur, which we should know. There are different fora. Obviously, there are defenses and out of court settlement. And as I said, discussing everything is not possible. So some of them we will discuss. What will not be on the menu are actual laws, because as lawyers, if I give the same talk at ILS Law College or in front of lawyers, it has a very different connotation, different slides, because there we discuss more about the acts, laws, the case laws, and how to defend, and how to write a written statement, and what is an evidence affidavit, and all those things, and when to ask for anticipatory bail, etc. But that is something I'm not going to do today, so that is not on the menu. So let us see warming up, and Dr. Patil sir very clearly initially only said this is something which we have to know. What are the fora available for complaints against any doctors or healthcare individual? These are the different foras. Somebody can go to the police and institute a criminal case. Somebody can go to a civil court and ask for compensation. Most probably because of the Consumer Protection Act has these 3 levels of consumer dispute redressal fora, so somebody can go there. Then there is National and State Human Rights Commission, where if you are associated with a corporation or a government-owned hospital, the patient can go there. There's Disciplinary Committee of Indian Medical Association and of Maharashtra Medical Council. And the bottom line is a patient can go and complain at all the places simultaneously. So it's not that if a patient has instituted a complaint with the police, he or she will not go to another fora. The patient has to decide. They can go to all fora. Number two, we have to also understand what is negligence, because every time we discuss this term negligence, every time in case laws it comes negligence held, not held. So what is negligence? Negligence is just these 3 pillars. It is a duty that the doctor has towards the patient, which is based on a contract, which is the doctor-patient relationship. And if there is a breach of any of this duty, and if there is a consequential damage. And very important thing which is actually there in the law but does not happen in courts is the burden of proving that there was negligence, there was some duty which was not done, there was breach, there was damage, is totally upon the complainant. So if you see Evidence Act sections 101 to 105, burden of proof is very important. It is actually on the complainant, but generally it never happens in the court. I have not seen in last 8-10 years. We have to only go and show the court or prove by various things that what we did was right. So, this is something which is there in the law but never happens in the court. Also, another thing which we have to understand is the basic difference between a civil or a consumer and a police complaint or a criminal case. Please understand, the crime is something which is against the state, and to constitute a crime, there has to be gross level of negligence. So just a little deviation from protocol or just happening of a complication, a police case generally is never instituted. So there are different sections which as lawyers probably we have to know more rather than the doctors. but the doctors should know that to institute or to constitute or to prove a criminal negligence is near to impossible unless there is a gross error or a big mistake which has been made, and which is also because of this section 52, which says that actions done in good faith for the benefit of a person is a good defense. And whenever a doctor does anything to the patient, it is assumed that the doctor is doing it in good faith. So that is something which we have to know. Another thing which we always discuss is a term called vicarious liability. What is this vicarious liability? It is a liability of a senior towards the acts done by a junior. And this liability is obviously only coming with only coming with civil or consumer cases and never with criminal cases, because the crime, which is, if it is constituted, it is an individualistic thing and it cannot be pushed on somebody else. So where in our practice so for example, where in your ophthalmic practice this vicarious liability comes, it comes when a PG student is operating under the guidance of a teacher. The teacher is vicariously liable, which we call as a principal and agent relationship. It also comes in your hospital when you are the doctor and your nursing staff or junior doctor is giving treatment on your behalf. We call it master and servant relationship. And it also comes if you are a consultant and the hospital management is there for a corporate hospital where you go and operate or admit patients. This is known as the independent contractor type of a relationship. So we have to understand that all these situations, the vicarious liability lies on the senior, the teacher, the doctor, or the consultant, and only for civil or compensation related matters in consumer cases and never in criminal cases. So this is what is happening now. No, we have to discuss why there are so many litigations, go to the base of it, and then come from below upwards and see what we can do to reduce these litigations. What do the patients think? They say doctors give them too little time, doctors do not listen, they do not explain, they have no sympathy towards the patient. Why do patients sue? If you ask me in one line, it is just lack of communication. If your communication with the patient is good, then probably the litigations can be brought down. So many times, probably in 30% of the cases, a proper explanation or maybe apology at some times can be very helpful in preventing litigation and all the harassment that comes later. Now, what has happened because of this litigations, which has risen in last maybe 10 or 15 years, is something called as defensive medicine, which has come up. So my clinical judgment says the patient has headache because maybe the patient has not eaten anything, but I will order more tests. I will order BSL, I will order LFTs, I will order RFTs, I will order a CT scan. So more tests, more specialist referrals, more medicines that is needed. And then this relationship of a doctor and patient, which was supposed to be a very fruitful, very nice relationship, is now become an adversarial relationship where every doctor thinks that something can go wrong with this particular case. So point number one, what are the common allegations? And these are cut, copy, paste allegations. If you see complaints made by lawyers against doctors, and I completely agree with Deshpande sir, myself, Dr. Mrinali, we have a small law firm here in Pune, and the first number one chapter and number one part of our constitution is we only fight for doctors, by doctors, and of doctors. We do not even give any consultations to patients who sue their doctors. That is very basic and very clear. So these are the common allegations. There are allegations of negligence, allegations of something being done without consent, communication lack, standard of care not there, loss of limb or life, mental agony, loss of consortium, mixture of above, and very novel ideas which lawyers come up with every day, adding to these allegations. So how do we achieve litigation-free practice? And we will talk about ophthalmology because all the cases that I'm going to discuss today are all ophthalmology-related cases. So there has to be good communication skills and counseling, nothing to be taken away from that. Consents, documentation, obviously ethical practice. I'm going to talk something about advertisements, which probably is very essential for people who do LASIK and refractive surgeries, and also in gynec where people do a lot of IVF. So following standard guidelines and protocols, mishap management, res ipsa loquitur, something which also requires some deliberation. So, but maybe we can discuss it some other time, is how to manage police, how to manage the mob, how to manage media, obviously details about indemnity insurance. And obviously, even after you do all of this, there can still be a litigation or complaint. So there is only one person, one boss with one thalaiva, the big one, God. So your prayers are always answered if you do them truthfully. doctor-patient relationship is an implied contract now. So it has changed. So we have become the service providers, and Deshpande sir is going to talk about it. So I'll not go through much of the Consumer Protection Act. The patient is a consumer, and what you take from the patient as consultation is consideration or the fees. And obviously there has been a greater openness. Everybody discusses. There is Google Guru. There are so many gurus which teach the patients half knowledge, and they come to you and they also know about Consumer Protection Act. And so that is why the focus is there, and it will be there for us to decide. So in very short, communication skills, counseling skills is a big lecture. There are role plays. We did it in 2010 in 42 societies all over India. And to sum it up, I have prepared some mnemonics. You can take a picture of this, or I can leave this. This is good. You can display it somewhere in your hospital. What patients should do, I call it prepare. That is plan, report, participate, agree, and then repeat what the doctor has told them. And communication is more than just words. Most communications are non-verbal. So your body language, how you talk to the patient, do not pick up your mobiles and keep on chatting when the patient is talking to you, so on. And so there's so many do's and don'ts, but please understand your body language is very important. And this is a mnemonic for doctors. I call it soften. S is for smile. O is for open posture. F is for forward lean. T is for touch, eye contact, and nod. So this is something which can come out of practice. This is not taught to us during our MBBS curriculum, and we have to learn and do it together. Obviously, you cannot be confrontational, combative, and judgmental. You are supposed to be a doctor. So calm, cool, composed is what you are always supposed to do. Second part is understand the law. And the irony is that, as sir said, ignorance of law is no excuse. Ignorantia juris non excusat is something, which we have to know and understand. Once again, my slides are not moving. Just give me 1 minute. Now everything is moving. Just all right. If that slide doesn't come, yeah, okay. So okay, I'll play it here.
I'll give you a suggestion. Go on the left side on the slide and tap it on that instead of the slideshow. It'll come automatically.
There's just a video which, if it doesn't play, I'm still okay with it, sir. So I don't want that video to play. I don't know why this is not responding. But anyway, if that video is not playing, I'm okay with it. I'll just start with the next. I'll just try once, because this just tells you that if you approach law from a long place, the law will also approach you at a wrong place. That's it. So, please do not approach law from this place what is shown. So this is a partial list of all the acts that you are supposed to know before you start practice. And irony of the situation is you cannot say that I did not know this act or I did not know that act. As practitioners of medicine, you have to know all these acts. And unfortunately, it's very difficult to know all these acts, and therein where the problem starts. And obviously, you have various sections of Indian Penal Code, and you have to understand few of them. Like we had unfortunate incidents in Jaipur where one of the doctors committed suicide, irrespective of the fact that, she could have approached us, she could have approached the local societies, and we could have taken action before all this could have happened. So this is something which I have to stress. I know some of the slides are not related to ophthalm directly, so I'm going to skip. Please understand that a doctor cannot be held for murder unless he does a murder as a human being. So I'm talking about a patient. So I know sometimes, at times you feel like murdering your wife, but that is a different thing. I don't want to talk about it. We can talk about it another place, another time. But for a patient, a doctor may not be able to, the charge of murder will never be put against a doctor. And it is only section 304A, which is cognizable and bailable. So you get bail as a right. So do not worry about it. And the difference, I already told you that for criminal offense, it has to be gross negligence. And this is something which is important. Again, from ophthalm point of view, surgery without consent, the first two are important for you all. Surgery on the wrong patient or wrong organ It happens in camps. There is a left eye cataract and right eye is operated. There are so many case laws on this. So please, do not do this. Is a res ipsa loquitur, means the thing speaks for itself, and very few defenses are available if something like this happens. The standard of reasonable care is measured by something known as Bolam's test, which came from Bolam and Prime Hospital. I am telling you this because whenever you talk to a medical legal consultant, or whenever you talk about cases, or whenever you see these messages coming on WhatsApp, these are all the words that you will come across. So let us clear all the words. Bolam versus Prime Hospital. It is a test of an ordinary skilled man, ordinary competent man, not of a highly competent man. So what you are supposed to know is somebody who's ordinary in your branch, and if you are capable of doing what he or she is doing, it is good enough. That is the Bolam's test. This is the mechanism. This is a mechanism which happens with all the professionals, and this is given by Supreme Court, that the investigating officer upon death in a healthcare institution will take an independent and competent medical opinion from government medical college or civil surgeon, and then only the doctor can be arrested, and that also under section 304A. And if the police do not follow this, even they will be liable for punishments. Dr. Sanjay Patil was there. He knows how one of our members, IMA members in Pune, and her husband, etc., were arrested. We all went with this judgment and guidelines to Commissioner of Police, and the bail was granted, and there was a complaint against the investigating officer. All right, let us now come down to case laws, because this is the crux of the matter. This is where you learn maximum. All the case laws are true, so I have just tried to shorten them and bring out only important issues. So in this case, cataract surgery was done. There was no pre-op care. There was no pre-op investigation. There was no high-risk consent taken. There was loss of vision, and rupees 5.5 lakh rupees compensation plus 50,000 treatment expenses were awarded. So you have to, be on your toes whenever you are committing to any surgery with respect to pre-op investigations, fitness, whatever is the standard protocol. I am so sure MOS, AIOS would have these standard protocols in place, like we have for all different societies, and your consent has to be really good and encompassing everything. Again, this is a cataract surgery was done on a 76-year-old patient. Now, considering that the patient is old, consent of the grandson was taken. So case of loss of vision was well defended and no negligence was found. But 25,000 plus 10,000 costs were awarded because patient's consent was not taken. So please understand, the consent is a contract between a doctor and a patient. Everybody else can sign as a witness, but not in place of the patient. Always takes patient's consent, and the doctor, as a doctor, you have to sign the consent too, because it's a bipartite contract where there are two parties involved. Consent, the patient has a legal right under Article 21 to determine whatever is to be done to his or her body. So consent is absolutely essential. The only exception is emergency, where you can do away with consent and you just help the patient. And also our Indian Medical Council Act, if you see the Conduct, Ethics and Etiquettes Regulations 2002, it says that before performing any operation, physicians should obtain consent. Now, if you do a surgery without consent, or if the consent is inadequate, and consent is one place where the advocates in litigations hit you first if there is a case of surgery. So then you are liable under tort law for compensation or damages, and under IPC for 349 and 351, that is application of force and criminal application of force, where 3 months imprisonment and 500 rupees fine can be put against you. So please be very sure about it. Consent follows the Indian Contract Act. I told you we are not going to go through the section, so I'll run through a few slides just for completing that. When two or more people are said to consent on a thing, when they think about the same thing in the same sense. This is one example where we have somebody thinking about the same thing in the same sense. This is another example where the same two people are thinking about the same thing in the same sense. They're thinking about war, but a consent, this cannot take place, because the reason, the objective for which you are consenting has to be legal. So these are different sections. I'll skip that. I'll directly come to, and we have to be, we are very thankful to our patients still, because they sign at any place. Some of the patients will read your consent, but it is a good idea that somebody from your side reads out the consent to the patient, explains, and then the patient signs. Different types of consents. There can be oral consent, but it is difficult to prove. There are statutory consents. For example, in PCP NDT, you have to take consent before doing ultrasound for a pregnant lady. There can be proxy consent less than 18 years. And then the guardian can sign. Written and informed consent. Now, this is an important part of the consent. I'll just go through a few of the titles: date and time, patient related factors, doctor related factors, two witnesses, one has to be independent, disease related factors, comorbidities, surgeries or procedure related factors. Anesthesia consent has to be different, which has to be signed by anesthetist. Blood transfusion consent has to be separate because blood is a drug according to Drug and Cosmetics Act. Special risks have to be mentioned, and you have to also mention that the relatives were allowed to ask questions and the queries were solved, and that is why you get a voluntary consent. In case of emergencies, nobody to give consent. It can happen in road traffic accident when you have trauma to the eyes. You can take hospital head, police or witness consent and do. Patient and relatives refuse consent for a certain procedure, you can take refusal consent. If consent, is it always written? No, oral consent is also okay, but then burden of proof is upon yourself. And some of the acts like Human Organ Transplantation Act, PCP and MTP, etc., they warrant you to take a written consent. Relatives consent only, is it okay? No, I already told you they are only witnesses. Consent has to be there between the doctor and a patient. If you want to know more about consent, this is the landmark case, Samira Kohli versus Dr. Prabha Manchanda. We always refer to this case, and the outline, the skeleton of consent which I showed you just now has come out from this case. Can there be a blanket consent? So for example, when we were doing our post-graduation at BJ Medical College and Sassoon Hospital, the sister of the operation theater used to take superb consent in Marathi. I'll tell you, because MOS, I hope everybody understands. She used to write down on a piece of paper, मी कुठल्याही डॉक्टरांकडनं कुठलंही ऑपरेशन कधी कशी आणि कुठल्याही भुलेखाली कधी पण करून घ्यायला तयार आहे, कोणाविरुद्ध माझी काहीच तक्रार नाही. Now this is a very dangerous blanket consent, so please do not do that. If you want to mix two procedures, suppose if you are doing, I don't know whether cataract surgery is done with glaucoma surgery, but if it is done and you want to have two surgeries, you can take a comprehensive consent. It can be taken by assistant doctors, no problem, but do not include everything, right? So do not include everything in it. It is not a spa or a massage thing that you do massage of head and everything else is free and all, etc. Please do not do that. Argument that it is beneficial, would save time in the future, etc., does not stay. I told you blood requires a different consent. Refusal of blood transfusion probably does not affect ophthalmologists so much. There is Jugaad technology, but do not use it everywhere. Consent for anesthesia has to be separate. I told you anesthetist has to sign it. How long is the consent valid? It is valid till the patient revokes it or risks and the factors affecting the procedure change. Shifting is, and we'll skip all these euthanasia, etc., because probably they are not related to your specialty, right? Cataract surgery was done, there was damage to eyesight, negligence was held, compensation of 1.9 lakh rupees awarded because records which were submitted to the court were very poor. See, please understand, whenever you do documentation, whenever you record, the records are patient's property. Patient can ask for a record by a written application. Once you receive that application, in 72 hours, you have to furnish all case records to the patient. So please maintain your records properly. Please take serious note of that is what I always tell all the surgeons. Now, you all are surgeons. Remember how you used to operate when you were postgraduates and write 2 to 3 pages notes. And now, how do you write notes? Okay, phaco done, cataract surgery done, all okay, goodbye, tata. So please don't do that. Please write proper documented things what are needed. Again, in this case, you can see cataract operation was done, loss of vision, after which there were 3 separate surgeries done. Patient was not furnished with medical records. Doctor said that records were destroyed as they were old. So now you have to know how many years you need to keep the records. What happens if there is a case, then how many years you need to keep the records. Negligence was held, compensation of 1,85,000 plus 12% interest was awarded to the patient. So medical documentation is everything which is related to the patient, health records, audio, videos, mails, faxes, images, checklists, everything. Why do we have very poor records? Because everybody thinks it's time consuming. We did not do, there won't be any litigation, no training, and patients go doctor shopping. So how many times are you going to make a paper? And the realization only comes if you are hit by litigation. Good record has to be correct, clear, comprehensive, chronological, and contemporaneous. So you have to take time, spend energy, delegate it to somebody. You delegate it to one of your staff or a junior doctor to complete it. What should be documented, date and time, all outpatient documents, copies of all reports, indoor case reports, copy of discharge card, and obviously consent. This is very, 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 very important, because one of the clear allegations, if I can say in Marathi, doctor आमचं कधी ऐकत नव्हते, आमच्या प्रश्नांना उडवा उडवीचे उत्तर देत होते. This you will always find in complaints. that means you lack counseling. We counsel our patients every day. Once you finish your cataract surgery or surgery, before going home, you tell the patient 10,000 things. He kara, he karu naka, he kha, he khau naka, ite basa, tite basu naka, he serial bagu naka. All that is counseling, but you do not put it on paper. That is the problem. So please put your counseling on paper. Very, very, very important. Electronic records is a good idea, but once you record it, you cannot, manipulate or change, and it has medical legal advantage. So if you have a software installed in your hospital, it's very good. You can store. Storage of documents is something, again, you can click a photograph of this if you do not know this, but MCI rules say that 3 years you have to keep all documents with you. Consumer Protection Act has a limitation of 2 years plus. Please understand, it is from the day of cause of action, and cause of action can be delayed if there's a late complication. So don't think 2 years get over from the day of your surgery. Civil, court says 3 years. There is no limitation for criminal law. So if you think something is going to go wrong in a certain case, or if certain case is going on, please keep all the records forever with you. IT is 6 years. Obstetric papers, you are not concerned, so I'll not go into details. If you want to destroy, so 3 years are over. If you want to destroy, what is the procedure? You have to give a notice in a local newspaper, one in English, one in vernacular language, and ask if anybody wants to get any paper. They have to come and apply during that period of 2 weeks or 1 month or whatever, and then destroy it 1 month later. This is the correct way of destruction. But nowadays, I say you make a soft copy and keep the records, at least for surgery, all the surgical records forever. Who are supposed to write? Everybody, doctors, nurses, midwives, patients, healthcare professionals, everybody has to write it. Now, this is something, which when I wrote, I think I have written 2 articles in Poster, and I have laid a lot of stress on this, because this is something I have seen in ophthalmology. Lot of guys who do LASIK and refractive surgeries do. I have seen people say 2 पे 1 free, इतना vision कम हो जाएगा, आपको माइक्रोस्कोपिक दिखने लगेगा, कपड़े के अंदर का बाहर का दिखने लगेगा. वो सब मत करो, please do not advertise. Indian Medical Council Act, chapter 6 is unethical acts. Advertising for soliciting patients directly or indirectly is unethical act, and medical council can, upon complaint or even suo moto, take action and remove the name of the RMP from the register. So please do not fall into this prey of putting ads like this, and do not do that. You see this case, refractive surgery was done for myopia, eyesight worsened, misleading and false advertisement was put in the complaint. So the complainant in the court says this was the advertisement. This is, see, when you put something in the ad, it's like an open promise that you are making, and which was accepted by the patient. The court decided upon it as unfair trade practice and deficiency in service, and 50,000 was awarded. See, we as doctors, we already have a lot of problems on our head. Please do not increase the problems by doing anything like this. Again, advertisement of a center to do away with spectacles. PRK surgery was performed, vision not improved. No negligence in surgery. Surgery was okay, but the court says violation of code of ethics, unfair trade practice, 1 lakh compensation awarded, and to remove that ad from the media, what was given in the court's decree. Moral, we are ethically not supposed to procure patients through advertisements. Please do not do it, and do not add to the already existing problems. Bolam test, I already told you. See this case, cataract surgery was done, lack of preoperative assessment, no ECG, no fitness, no physician examination, test dose of local anesthesia was not given. Now, again, it's a point of debate whether your protocols allow you to give local anesthesia without test dose, because I have seen a lot of people do a sensitivity test, and it is also a well-established fact that even after you do a sensitivity test and it is negative for hypersensitivity, patient can still have hypersensitivity reaction. So it is not a must. Now it is upon us to prove by looking into protocols, because there is another case of spinal anesthesia where it was alleged, and a police case was put on under section 304A, that they knew that this drug can produce hypersensitivity without test dose they had given, but we went to High Court and got that case quashed. So you have to follow your protocols is all I'm saying here. Negligence was held, rupees 2 lakh compensation and treatment were awarded. Detailed preoperative investigations as per protocol are must, especially while managing comorbidities like hypertension, diabetes, etc. So please follow all your protocols to the last line. Cataract operation, patient had a complaint of hypertension, diabetes. Post-op condition, patient deteriorated. No facilities of emergency care like oxygen, defibrillator, etc. Shifted to another patient. The patient died. Now see, it is absolutely not done in this era that somebody who's posted for a cataract surgery dies like this, right? Negligence was held, compensation of 3 lakhs were awarded. Ophthalmic OT is like any other OT, and you should have all equipment and drugs for any emergency. So please have your oxygen cylinder, please have your. In my hospital, we made it a point that my OT and Rudita's OT are different, and we have different boil apparatus, and everything is different in these two OT. So there's no crossover, nothing. So please treat your OT as a OT where any mishap happens, you are able to manage it. Now, again, I told you there's something called as res ipsa loquitur, where it is very difficult to defend a case. See what happened in this case. Eye damage to 84 patients in a charity eye camp, public interest litigation in the Supreme Court under Article 32, which is breach of fundamental rights. Police registered a case under Section 338, which is grievous hurt against the doctor. Compensation of 12,500 paid to each victim. More importantly, Supreme Court has approved guidelines from norms how to conduct an eye camp. This has come on 9th of February 1988. I don't know if after that there were any modifications, but if you are trying to arrange an eye camp and if you have Supreme Court guidelines, you have to follow Supreme Court guidelines. And then if something goes wrong, it is okay. But if you are not following, then we are in a big soup. Again, in this case, radial keratotomy was done, loss of vision, patient below 21 years of age, myopia was not stable, patient was not fit for keratotomy. So please go through the indications. Here, as I understand from, I do not know much of ophthalmology. It was more of a optional subject also for me during MBBS. But anyway, what I learned from this case is that, somebody who's unfit for surgery or somebody on whom that surgery should not be done was done. And then negligence was obviously held. 1 lakh compensation, 12% interest from complaint was awarded. Moral, one should adhere to standard practice guidelines and without deviation from it and follow strict asepsis. This is what res ipsa loquitur is all about. Again, this is a case again of res ipsa loquitur. See what happened in this case. Eye washing was done. Carbolic acid was dropped in eyes. Now, I'm not sure what would have happened, but something may went wrong between washing the eyes through maybe in the normal saline or distilled water, and somebody put carbolic acid drops. There was loss of vision, negligence held, 1 lakh compensation. There is no defense when this res ipsa loquitur of this sort is applicable. And obviously, please understand, this is also where the vicarious liability comes in. So even if this is done by your sister or junior doctor, rest assured that the patient will also involve you in the case. We definitely have this act just to complete the list against vandalism, which the patients do. So please make a big, board of this and put it either in your waiting room or where people can read and see. This is an important act where if people do vandalism or they threaten the doctor, etc., then there's 3 years imprisonment, 50,000 rupees fine, and it is, cognizable, non-bailable offense. That means the perpetrators get arrested without warrant and they do not get bail as a right. Last part about indemnity insurance, you should have it. I am told that Ophthalmic Society has their own indemnity, which is fantastic, very good. And I have discussed this with Ulta. She told me that it's very good and you're getting it a very good premium. Only 2-3 things I'll tell you about this is, please read your anyone near to anyone accident ratio, and do not divide it too much so that you get the whole amount in case it is needed. Point number 2 is also discuss about out-of-court settlement, because a lot of these indemnity insurances will not pay for out-of-court settlement. And very importantly, discuss with them that you will hire your own lawyer. So please understand, if you have done an insurance and lawyer comes from Bangalore, he is not even 10% interested in your case. So you should hire your own lawyer, which the insurance company will pay. A, and B, if in case you feel there's out of court settlement, then the insurance. These are the 2 things that you need to discuss with your insurance company. So dear friends, I understand that litigation free practice as of now, as on today, appears like a holy grail, very difficult to achieve. But you need to understand the law. You need to put proper consents, proper documentation, obviously indemnity, doctor-patient communications. I told you the ones which I've highlighted here: mishap management, management of police, mob, media, probably require 1 hour each. So maybe some other time in a physical format and taking questions, we can discuss all of them together. All right, and this is the video which I show everyone, and you should take help of Deshpande sir, myself, or Mrunali. That is the law of leopard. The leopard is the law, the deer is the doctor, and it happens throughout the life of the doctor. And you need medical legal consultants who can take the deer and take it away from the leopard. So as medical legal consultants, we are always there to help you like this. So do not worry. we are always there. And whenever you enter practice, this is how you are thinking, and thinking not only about how to earn money, finish all the EMIs, etc., but also how to procure patients and not get litigation. Trust me, don't worry. Together, Sanjay Patil sir was the IMA president. We have now Taswala sir, MOS president. With such good leadership, we have to strike at the correct place. Ek ghav don tukde. These are our leaders. I respect them a lot. Deshpande sir, good to see you. I have heard so much about you. It's a privilege to give a talk. And when you are speaking, आणि जे काही चुका झाल्या असतील, please सांगा sir. पुढच्या वेळेस त्या improve करेन. So, do not worry in your practice. We are always there. Together we stand tall. And I always say this in all my medical legal presentations. You want a litigation-free practice. Whenever you're talking about your colleague in front of any patient, control your tongue. If you can control your tongue, no doctor is giving wrong treatment. You can always say that is what that doctor feels according to his judgment. This is what I feel. Both treatments are correct. If you do not use the wrong words, if you control your tongue, I think that is one thing I did not put on slide, but it's one of the most important things that will go in long way in prevention of litigation. Thank you so much for a patient hearing. I know I have exceeded a time a little bit, but medical legal, I always exceed time. Thank you so much. Thank you.
Very, very nicely covered, Manish. I am really impressed the way you have covered the whole, almost a textbook on medical legal jurisprudence. Very good. Sanjay, over to you.
Yeah. Thank you, Manish. Excellent talk. One of the best I have listened so far. You have given all the details about the various cases, also protocols, importance of protocols, standard of care, as well as all the relevant things, how to avoid the litigation in the ophthalmic practice. There are few questions, but I think we will finish one more talk and then we'll take questions, right?
Yes. Yeah.
So coming to the second talk is biting teeth of new Consumer Protection Act 19. Our faculty is Dr. A. Deshpande. He is MS, DOMS, LLB, LLM, MBA. He is a medical legal consultant. He is a director of IMLCS, Indian Medical Legal Consulting Services Private Limited. He is a director and eye surgeon from Guru Prasad Netra Rugnalaya Private Limited from Aurangabad. At present, he is a chairman of Legal Committee, All India Ophthalmological Society. He is a chairman, Legal Committee and advisor, MOS. And he is a past president of Maharashtra State Ophthalmic Society. And he is a legal advisor of Vision 2020. So I request Dr. Deshpande sir to start his presentation. Thank you.
Welcome to all. Dr. Manish has covered a lot of things and he has told everything about all the things, criminal, civil, and other things also. Now I am going to speak specifically only on the Consumer Protection Act. That too, what is the difference between the new and the old? Because new act was, previous act was done really for the consumers of all kinds of people. But now this act is not done like that. It is done with keeping in front the builders in the Delhi or the big cities, and they have formed this act, and afterwards they have applied it to all the peoples. So the things are very, very different in what are seen in our practice. Now, the Consumer Protection Act 1919, previous act is totally peeled off. Peeled off means totally cancelled. Nothing is left of anything from the old act. So this new act act number is 144, that is 2019, and it was applicable from 20th July 2020. It has started. Now, in the previous, when it was started, there was a confusion whether it is applicable to the medical practitioners or not. But what was done in legislation, that when there was IMA was introducing and saying that medical health services should be excluded, and the minister excluded the name of the health services from the active list. But what they done is to provide of facilities in, but what they written in that is the services means services of any kind description which is made available to the potential users and includes but not limited to. This word they have added, and this word has made everybody that this act is applicable. So this is the word which many people did not recognize that this act is applicable because of this word, and now this is applicable to us as it was. But the total difference is there in the both acts. The previous act was mainly focusing on negligence of the doctor. If the negligence is there, then only the doctor was prosecuted. But now it is not true. It is not think that negligence is not the only cause. There are so many other causes under which the doctor can be prosecuted. The difference, first we will see the difference what was there in the previous and new act. Previously, there was a limitation of district commission was only can say the damages up to 20 lakh, but up to 1 crore now. The district commission can fine or you can say the damages to the doctor up to 1 crore. So what is this? And previously it was the limit of damages. Now the limit of putting the cost of bills in the court is required. So up a limit depends on bill paid, but no limit to demand even more than 1 crore. So now there is a 1 crore of bills. If they are there, till that, it will be lodged in district forum only. So which hospital can do a bill of 1 crore to the patient? Practically negligible or not. So it has really kept it because they wanted that all the cases of the builders should not come to the higher courts, but they should lie in the lower court and lower court only at district level. So they have put the limit of depends on bill paid. So how much he has spent is limited, and one flat transaction crosses more than 1 crore in a metro city. So this is the aim, and how that is formed, I am going behind that. Then state commission, previously it was 20 lakhs to 1 crore. Now it is up to 10 crores, and national commission more than the 10 crores. So these limits are too exorbitant. So accordingly, we have to do our insurance policies also. Previously 10 lakhs, 20 lakhs was sufficient because everybody used to lodge the case in district forum. But now district forum can cause you 1 crore rupees damages. So you should have at least 1 crore. And that's why Dr. Manish Machu has said that our ophthalmic association has done something for that. Really, we have planned and brought down the premium from 30,000 for 1 crore to 8,600 rupees for all the ophthalmologists. And also I will declare that this is also possible for all doctors of all faculties. And so it can be done. They should also can have this premium and the security also. And from that point of view only, we done the negotiations and brought down the company below. Jurisdiction for lodging the case was old. It was the jurisdiction of the district place or the state or the India. But now at the cause of action or at the place of residence of workplace of the consumer, that is patient, or so a patient gone to the Delhi in some hospital and got the treatment, he can come back to the Tamil Nadu and put the case in district court of the Tamil Nadu also now. So doctor to Tamil Nadu every time, everywhere, and attend the cases. So it has become very difficult, and also online cases can be lodged. So from anywhere they can lodge the cases. Only the facility is that doctor also can attend on. Appeals, there was different in appeals also. Old provision was deposit 25,000 and go in the appeal. but limitation period was 30 days. But now they have changed. Deposit 50% ordered amount. So if the district forum orders 1 crore, you have to deposit 50 lakhs in the court. Then only you can go in the appeal. So it is practically difficult for a doctor. It is practically difficult for a practicing doctor or even a corporate hospital. So it is very difficult. And so this change is made in favor of the consumers. A limitation period also was increased to 45 days. The appointment of judges, old provision was judges and staff was appointed by judiciary. But that is also now changed. The clause number 29 of the act says the judges and staff will be appointed by the central government, and the qualifications and experience will be decided by the central government. So till the central government is good and it's sticking to the laws and everything, it is well and good. Or other day, anybody can sit in the chair and can decide the case. So this may happen in future. The new clause, new biting teeth. This was the only changes which the previous act and new act there was. But in new law, there are another biting teeth, another clauses which are going to trouble the doctors, and that is clause number 36 of the 3. If the complaint is not heard in 21 days, then it will be taken as admitted. Previously, it was that if the complaint is not heard in 21 days, it was supposed to be dismissed. Now, if it is not heard, it is supposed to be admitted. So normally, a case doesn't come in the court within 21 days. So all the cases which are lodged, they get admitted in the court. So it becomes an easy way to enter in the court. Clause number 37, 1, 2 and clause number 74 says, after first hearing, the complaint will go be referred to mediator. So as Dr. Manish Machiv was saying, that outside settlement should be taken into consideration by the insurance companies. It is right, very right. But now the problem is that the government has appointed, consumer courts has appointed their own mediators, and every case will go to the mediators, and whatever mediation was done and compromise is done, that is ordered by the court. So the insurance company has to give the compensation. There is no other way. So there is this clause in our policy which we have brought down. Consumer mediation cell. Now there is a form in the consumer court, a mediation cell is formed. A person is appointed who will do the mediation. The thing, bad thing, it is a good thing that if the case is settled, what is bad in that? But it is not true to the face what it looks like. I will speak something afterwards, little bit. The new clause, that is clause number 92, 49, 2 and 49, 2. Any terms of contract which are unfair to the consumer can be made null and void by state or national commission. So another clause is there. Even if you do any clause in contract or in your thing that this is the, if you have taken the consent, this, and things also you have taken the in consent, but if they are against the patient's benefit, they will be made null and void by the court. Court has this authority. Previously, this was not there. About the mediation, I want to say that mediator, what is going to happen, or it is happening just now also. Order, when the mediation case is lodged for about 50 lakhs, 60 lakhs, 70 lakhs, then mediation, it will go to the mediation. The advocate says, doctor, it is 70 lakhs, 50 lakhs. We will do compromise, 5 lakhs. Okay. So other also advocate says, okay, 7 lakhs. And they get the compromise and get the order and case is over. But the 7 lakhs are gone from the pocket of insurance or doctor unnecessarily, because this is pre-decided things. Though so many things as nowadays, sorry, madam, I will speak little harsh about the advocates, though I am an advocate. But the thing is that the advocates only say, just sign here and go away, you will get something. And really, they fight the case, and in this mediation, they earn lot of, advocates also earns, patient also earns, and the doctor only suffers. So it's okay. This is law. It is made by the government. We have to obey it. That's true. So clause number 35, this is the drawback of mediation, what I am going to say when I was talking. Clause number 35, 1, 2, product liability action may be brought by complainant for defective product and in service. This is the most important clause which is not taken care by the doctors or even advocates. Still now, still the advocates are going against the doctor on negligence point of view. That is well and good, but when they will understand this 35, 1 and 2, doctors will be nowhere, because this is product liability. So they are saying that your product is not good, means your product is service, and your service is not up to the mark. And if they are not up to the mark, you that will be punished for you, and damages will be there. That is, if the freeze is formed in a factory, and if the freeze is having manufacturing defects, the owner forming the freeze can be sued, or a trader who is selling that can be sued for the defectivity of the freeze. Like that, a doctor or a hospital can be sued for saying that your services are not up to the mark. Who is going to decide up to the mark? Whether the patient is going to decide, whether the court is going to decide, who is deciding up to the mark services are not there or not there? So this is totally vague and totally difficult, and anybody can say that if you are not having CT scan, MRI, your hospital is not good because their facilities are not there. If ophthalmic doctor is there, if you are not having B scan and your hospital is down. If you are not having OCT, if you are not having fundus camera, you have not taken the photo of the retina, you have not done the OCT before surgery, your services are not up to the mark. And so your product is below standard, and so product liability lies on the doctor and the hospital, and he can be easily sued. It is very difficult to unprove this. It was very easy to unprove negligence, because with the documentation, with all the things, the negligence can be avoided. That is said that there is no negligence done by the doctor. But this is, up till now, it is a very difficult thing. And lastly, the chapter number 3, Central Consumer Protection Authority. This is something totally different. Previously, so moto, there was no interference of the medical practice or the hospitals. But now with this, there is so moto interference by the government machinery, by the central government, by the state government, or any authority which is appointed for these purposes. And what they are going to seek to be known as the central authority to regulate matters relating to violation of rights of the consumers, unfair trade practice, and false or misleading advertisements. So that Dr. Manish has said, misleading advertisements. Yes, whatever you have advertised, maybe in posters, maybe in your brochures, maybe in your cards or whatever, that will be taken care of these people. And if you are doing that, they can intervene you and punish you, public and consumers, and to promote, protect, and enforce the rights of consumers. So if they find that this is being done, this is there, they can go inspect, harass, and put the cases on them. And so this authority is there. Clause number 15, investigating authority, that is 15.1. The central authority shall have an investigation wing headed by a director general of the purpose for the conducting inquiry and putting a case. So anybody that will become the what is called as the Inspector Raj, because one day anybody, central government from come and say that it is not there, it is there, it is there, you are doing this, you are doing that, and you will have no answer. Like the income tax people do, like the other people do, another authority will be there who will judge your working, who will judge your standard, and even if the standard is good, they can blame you, and this authority is there to trouble you. And then they can put the cases, either the criminal or the civil or the consumers. They are authorized to do that. So these are the new tips, the way the Consumer Protection Act can act upon the doctors, and the practice becomes very miserable. And for an individual doctor, really, it is a panic. And to start as a solo practitioner, so many things are there with him, and it is very difficult to survive a solo practitioner nowadays because of the investments and laws and regulations and this Consumer Protection Act. Thank you very much.
एकदम छान झालं sir. Fantastic.
Thank you. Thank you.
Very well covered. Over to you, Sanjay.
Thank you, Dr. Deshpande sir, for an excellent talk on CPA. You have given a detailed information about the new CPA to 2019, and there are 2-3 questions, but we have third faculty. She is Advocate Mrunali Kamlapurkar, and let me introduce Advocate Mrunali to you. She is a BSc LLB. She is a medical legal expert. She handles all the litigation matters of GM advisors. They are the bridge between the healthcare and legal system. And she has a standing of 5 years at the bar and has experience in handling matters pertaining to medical negligence, civil disputes, criminal matters, including but not limited to Section 304A IPC, consumer, DRT, MSME, and bails and anticipatory bail. She is experienced in handling legal compliance. She practices across the cities in India. Advocate Mrunali, I welcome you. And let us start with the panel discussion. But before going for question answers, I request Advocate Mrunali to give an overview or your observation regarding this increasing litigations in the medical field, and also the future of CPA cases for 5 minutes.
Thank you, sir, for the introduction. It's a pleasure speaking with you all. Actually, like, it is a boon or a curse, but because of Google, everyone is quite aware about everything. They know all the forums where to apply. So right now, taking a proper consent, following standard protocol and practice is the only solution, which right now is important.
And about the future of CPA and its applicability.
So Consumer Protection Act, as Deshpande sir said, they have given a wider scope, and even the stamp duty over there is very less. So for civil, if you want to go for a civil case, if it is free of cost service, then people go for civil. But now consumer, we usually raise bills. We have the IPD, OPD papers. So for the Consumer Protection Act, it is very easy for people to go before the forum. As sir mentioned, admission of the case is also very easy. So following all the standard and taking care is the only option which we have right now. Just one thing I wanted to mention, that whatever cases we are seeing, the burden of proof usually lies on the complainant. And thanks to the society that you all are with, the association and the expert opinions, usually the complainant don't have any. So we from the opposite side usually mention all the opinions, all the textbook references, all the journals, and all the all the information that is from our point of view.
Okay. Thank you. We'll start with the questions on litigation-free practice, Dr. Manish.
Yes, sir.
The first thing is, many times if the patient is grumbling and is saying that because of you I lost my vision and everything, And if he complains to the police, will this police arrest me in the middle of night, or any provisions like that, arrest of any doctor?
No, sir, no. So there are Supreme Court guidelines which we've discussed so many times on the fora. There are very clear-cut guidelines which Supreme Court has given in Jacob Matthews versus State of Punjab case, where the Supreme Court said that the investigating officer should not file any complaint unless there is prima facie evidence of gross negligence on the face of the case. So first authority is given to the investigating officer. Only if he feels that prima facie that there is some gross negligence happened, he can file a complaint. Point number one. Point number two, during investigations, he is supposed to collect the case papers, he can take depositions and send everything to a government associated committee. So those committees are either in the government medical colleges or the civil surgeon, and get their opinion. And we have discussed n number of times with these committees also that to say that there was a negligence for which a criminal act or a section of the IPC can be put, please mention that it is a gross negligence. So some negligence here and there, so that somebody is not monitored a particular drug, or there's some reaction and some drug was given late, etc., cannot be gross negligence. So only if the committee says there is a gross negligence in their report, then the police will put an FIR and a section of 304A, which is in case there is death, then death due to rash and negligent act. In case there is loss of vision, then section 338, 337, where you have grievous hurt can be put. Although these sections are cognizable where a doctor may be arrested, but they are bailable sections, so that you go to the police station, you apply for bail and you get bail. So to answer it in one line, if there is a loss of vision and somebody is gone and reported or put a complaint to the police cannot come and arrest a doctor.
Thank you, Manish. And Advocate Mrunali, what is section 302, and is it applicable for the medical professionals? Because recently in Archana Sharma case, the police have applied section 302. So is it applicable for a medical profession?
No, sir. Actually, 302 is not at all applicable to a medical professional. 304A is applicable to medical profession, because if there is gross negligence, as Dr. Machwe stated, only then there is arrest. But again, as doctor stated, the police can't come to your OPD and say that you are under arrest and you need to come with us. Right. They need to collect the documents. They need to check all the papers which need to be sent to the authority. Only when it is stated that there is gross negligence, there would be arrest.
Patil, 302 is punishment for murder. So it is very clear that whenever we talk, I'll just, this one point probably I missed in my talk. There's one point about a crime. So there's a very famous Latin saying which says that for crime, two things have to be there: actus reus, the act, and mens rea. So actus non facitrium nisi mens rea is something which was, it is taught to us always that whenever you are talking about crime, there has to be an act and there has to be guilty mind. Now, for a doctor, there could be an act, for example, a surgery or a particular treatment, but guilty mind will never be there. So intention of that doctor to do harm to the patient is never there. And for 302, which is murder, you need to prove guilty mind. Now 304, the act only is reckless. So you don't have to prove guilty mind. That is the reason why 304A is applied and 302 can never be applied. So that is it. So rest assured that the charge of whatever happened in Jaipur happened because of the high-handedness of the politicians there. I still feel, I know there would have been so much of tension, but through my committee, through my Foxy president, I still feel that the doctors should have had some patience. They should have contacted other people from IMA, and these things. You know about the case from Hadapsar, what had happened, and because IMA was all together and we were united, we could do what we could do, and so many of us, I mean 20 or 25 of us could go and meet Commissioner of Police then and there. So a lot of things can be done, but 302, no, it cannot be applied.
Doctor, I just wanted to mention one thing. Whatever happened in Jaipur case, we all are white collar people. We are not used to police coming to our hospital and getting the FIR and getting the arrest done. So people like doctors get panic, and through that panic situation, everything happened. So if people like if the doctors stay calm and if they contact other people, they speak to the peoples, take the advice of the advocate, maybe the matter would be resolved more easily.
Right.
I will add to it
Yeah. Yes, sir. Yes.
that what the thing is that when FIR, about FIR, what happens about the doctor, because it is related to the Jaipur case, it is not like that, but the mentality of the doctor about that. So whenever there is a FIR lodged by the patient in the police station, police has no authority to do anything against the doctor except the inquiry. That's true. But whenever a fire is there and police comes to the doctor, where the doctor is sitting in the chamber and seeing the patient and interrogating and stopping the patient, that picture of the scenario affects the mind of the doctor. And doctors being a soft target, they feel very bad and they feel shy or they feel very guilty, and so this guilt may increase. And what happens in Jaipur was like that only, because he felt what is insult they have done, or the insult is being done. So everywhere the aim of the patient to file a FIR is only to trouble the doctor with the police and take the benefit in this way or that way. So that definitely helps to the patient by doing this. And so this, some doctors becomes the victim of that scenario rather than the actual thing.
Sir, in continuation to this, do you advise our members that they should keep some documents ready with them at their clinic about some judgments or anything you wish to convey to our members? Any documents one should keep ready with them?
So my
I will
suggestion,
say, keep the phone numbers of doctors like Manish, like Kulkarni, Mranalini, and like me. Just ring, we will speak to them. And
Right.
I am sure, as I am being in the chair of legal cell of the All India Ophthalmical Society, that is my duty to help the doctors all over in India in ophthalmology. And I will not limit myself to ophthalmology only. So I will give my open thing that anybody can call me at any time and can have my advice free of cost, no charges, nothing. And I will help there and there only. So he will have consolation, and police also can understand what they are doing.
Right, sir. Thank you, sir. And one more question is, can we challenge the medical expert committee's opinion?
yes, yes,
Short answer.
of course.
Yes,
So
we can challenge, right?
if the medical committee has given a certain opinion which you think is not correct, the medical committee opinion, especially for a police case, there is once the charge sheet is filed and the witnesses are called, there's something called as cross examination. So you have examination in chief, cross examination, and re-examination. So in cross examination, definitely whatever report they have given, you can also challenge the post-mortem report. You can challenge the report for negligence which the medical board has given. So it happens. It happens. So generally, what I have seen generally is if you give them a correct. So now we are talking about death again, very rare for in ophthalmic situation. But if you give them a proper history, they would definitely be there and they would try to find out what really went wrong with the patient. And all those are our own classmates and our own people, sir. I really don't see any big issue happening at any point in time. And I completely 100% agree with Deshpande, sir. You need not keep a single paper. You just have to have the correct phone number at the correct time and the matter gets solved. So just one phone call made to the HOD of forensic medicine solves a lot of things. I'm practically telling.
I will add to it, sir.
Yes,
what Dr. Manish is saying, that is correct. But what I will add, whenever there is a medical report, that whether it is from a civil surgeon by a body of the civil surgeon formed, or whether it is from the medical board, that also depends upon you. Many times the judges have the authority to have a second opinion of the medical board. on that, and they can even refer the case to some another medical board out of the state and can have the opinion if they feel like that. But the opponent also have authority to apply to the judge that I want a review or a second opinion on that, and with the consent of the judge, it can be done.
Sir, in
And doctor
continuation
also
of
has
this,
the same authority.
yeah, in continuation of this expert committee, there is a question for Dr. Deshpande that in CPA, is there any provision or they ask for, do they ask for expert opinion in CPA cases?
Yeah. Previously, there was a High Court judgment that every case of the CPA should be referred to a medical board, and if medical board says that there is a negligence, then only case should be admitted. But afterwards, that judgment is overruled by the Supreme Court again and says that it is not necessary to refer every case to the medical board, but where that discretion is with the judge, that if he wants, he can send the case to the medical board and can have the opinion, and then he decides whether to admit or not to admit the case or conduct the case. Secondly, the opposite party also can have that thing, say at the same time, the doctor that is a opponent of the patient also have the right to ask for second opinion to the judge. But the discretion of the judge is always there, whether to refer or not to refer.
Sir, in case of CPA, we wish to have exclusion from this CPA. Medical services should be excluded from this CPA. If at all this wish is not completed or there is a issue, then what is the solution you would like to give to the government?
The government cannot do anything if the medical services are to be excluded from the Consumer Protection Act. One has to go to the Supreme Court and apply V. Shanta case in full quorum, that is a full bench. And if they give the decision against the V. Shanta case and that is overruled, then only the medical profession can be deleted from the Consumer Protection Act. Otherwise, this not the central government, not the state government can delete it.
By making a law, sir, it's not feasible. If the executive takes it up and makes a law to overall amend what is happening now.
No, Supreme Court judgment can be overruled only by the Supreme Court with full bench.
Full bench. Okay.
So Manish, there is one comment regarding what you said, that ophthalmology was optional for your undergraduate curriculum, and the delegate is saying that court should keep ophthalmology optional. So that's all from the questions, and thank you, panelists. Over to Dr. Jignesh and Dr. Rajesh.
Yes, big thank you, each one of you, for making this webinar very interesting and very, very informative. Lot of points, I think, I'm sure none of our members were aware of what Dr. Manish Mashwe, Dr. A. Deshpande, as usual, is always there beside us. For any problems, any mishaps, is always there to guide us throughout. That is more than important, that we have a star person with us to guide us. And today, Manish has added, we say, icing to the cake by giving us a very good insight of how to achieve litigation-free practice. And very good points, well covered by the advocate Kamla Kutkar ma'am. It's very kind of you to be part of our medical fraternity and giving us very valuable advice. And of course, Amara Sanjay bhai, very well moderated. He got the best out of the faculty. He was the right person chosen by me. So I should get a little credit also for that.
You are always credited. Being our president, you are always credited.
I know Sanjay's potential, where to put who and get the best out of it. And that is how we have Manish also. We just, it was very nice of Manish. We are over a dinner meet, we decided we should have something for the ophthalmology. And he readily accepted my invite. We would like to have a talk on that. And so nice, it was so well covered, sir. And with you there to back up so nicely, maja aa gaya, sir, aaj to. खेल में बहुत ही मजा आया and lots of points were well covered. Thanks each one of you and of course the enrolled people. A proper vote of thanks will be given by our Honorary Secretary Dr. Rajesh Joshi. Before that, we'll have a small video from the enrolled people. Sayyed, can you play the video please? Then have a gallery view shot and then a quick vote of thanks from our Secretary. It was one of the best webinars I think MOS had on Medical Legal Committee. A true insight. Over to you, Rajesh. And
Yes,
then
sir.
we have the screenshot.
Yeah.
Gallery view shot. Yeah.
As you said, that was really informative and useful webinar, I would say. The crux of today's discussion is consent is very important before taking patient for any procedure, and physical fitness before surgery and standby anesthesia is absolutely essential. May it be a small procedure under topical or local anesthesia. It is a tight rope walk for the ophthalmologist or any specialist, I would say, daily to avoid any litigation. When I see or operate any patient, it is always at the back of mind, is this the patient? It is not going to be a fear-free practice. One has to be very vigilant and always. On behalf of MOS, I thank Dr. Manish Machibisar for his talk on achieving litigation-free practice. I hope his valuable recommendations will help to achieve litigation-free practice. Thank you, sir, for sparing your valuable time and guiding us. When CPA came into existence, there was a lot of debate. Still, there is a lot of confusion amongst doctors. I thank Dr. Deshpande, sir, for clearing many doubts. As usual, your talk was to the point and informative. I also thank Advocate Mrunalini Kamlapurkar for her valuable inputs. Thank you, Patil, sir, for conducting the session so well. I'm also thankful to all those who have joined on virtual platform for today's webinar, and thanks to Entod for the technical support. Thank you all and good night.
Yeah, let's have a gallery view shot, please. Keep all your videos on, all the panelists. Sayyed, please do the needful.
Yes, sir. Done, sir. Thank you,
We
sir.
have the star faculty today. We have an advocate with us. Manish, can you share her number also with her permission, of course?
Yeah, of course. Mrunali's number.
Yes.